A couple of concur, not concurs while we wait for a few of the struggling senators. So, Jamie, we'll start off with House Bill, what is it?
Senate Bill 607.
Senate Bill 607, I think it's Senator Jackson's bill, so go ahead, Jamie.
Thank you, Mr. Chairman. So Senate Bill 607 prohibits a person from killing or injuring a service animal or allowing an animal that the person owns or over which the person has immediate control over to injure or kill a service animal. There was a provision in the bill as originally drafted that prohibited a person from interfering with a service animal or allowing an animal that the person owns or over which they had control over to interfere with the use of a service animal. So the committee, JPR, had taken that provision out, the interference provision. The House put it back in, and it would carry, just for the interference, it would be a misdemeanor, imprisonment not exceeding 1 year, or a fine not exceeding $1,000 or both.
Senator Jackson, do you want to do it?
Yep. So it provides a person may not willfully and maliciously interfere with the use of a service animal or allow an animal that the person owns or over which the person has immediate control to interfere with the use of a service animal. They put that provision back in. The Senate had removed it.
I mean, this gets back into why we removed that. You can't make it a crime. I mean, what's the criminal penalty? You can incarcerate somebody for this now?
Right, it would be 1 year, $1,000 or both maximum.
Yeah, so you can do a year in prison for, like, throwing a service dog a treat? I mean, come on now. You talk about over-criminalization. That's crazy.
Yeah, I mean, look, there are a number of ways to interfere. You could have that service animal could be for a person who's blind, and you do something there. I'm sorry. That service animal could be used for a person who's blind, If you interfere with that person walking through an airport or wherever, you could actually injure the person. So I move to concur.
Yeah, the part that we struck, the first part that we left in was interfere with the use of a service animal or allow an animal that the person owns or over which the person has immediate control to interfere with the use of a service animal. And the part that that seems okay, but what we struck was by intimidating or basically otherwise jeopardizing the safety of the service animal or its handler. Even if that's so vague, jeopardizing the safety of the service animal or its handler. If you jeopardize the safety of anybody sufficiently, that would be an assault or a battery. And to me, this is just so vague. Otherwise, intimidating the safety. That could be accidentally intimidating.
So Senator, that provision didn't go back in, just that last part, otherwise jeopardizing the safety of the service animal or its handler. It was just the first part, so it's just just limited to the interference.
So now what would the language say then? I'm sorry, I misunderstood.
Sorry, you're right. The original provision did have a clause at the end there that said, or otherwise jeopardizing the safety of the service animal or its handler.
Right.
Just that piece did not go back in. So the House just stuck to everything before that comma at the end there.
Okay, all right. So I think that was the part we really objected to, was that last part, and they basically agreed to us on the last part. Where are you? Oh, you're over there. I'm looking up here. Yeah, but it's okay. All right, I'm fine. fine.
So I think it goes to, the first part of it goes to intent. If someone's intentionally interfering with the service animal. Hey, look, man, I don't talk about your laws. Be respectful. A little bit. Try to.
Case again. Jimmy,
Sorry,
just-
what's that, Senator?
Just another, one more clarification. So what is it, so now with what the House sent back, 'cause I'm looking at the reprint, so that's probably, it says, so it's a person may not, and it's struck intentionally and recklessly, and it says willfully and maliciously. Is that
Right.
where it is now? That's,
Right, willfully and maliciously is still the requirement.
that's what the House is, so we're concurring with that language.
Right, and that's the language that the Senate used as well, was willfully and maliciously.
Okay.
But the new language is that they may not willfully and maliciously interfere with the use of a service animal or allow an animal that the person owns or over which the person has immediate control to interfere with the use of a service animal.
Period.
Period. Right.
Thank you, Jamie.
I'm sorry, what, Senator? It's an or. So the person, the defendant couldn't do it or allow an animal that they have to do it.
Yeah.
Oh, willfully and maliciously, I'm sorry.
Now that the willfully and maliciously language has been pointed out, I don't see how giving an animal a cookie or petting an animal could possibly be construed as constituting willfully and maliciously injuring the animal. So I'm in favor of the Senator Jackson's motion to concur.
Here, correct. Do we need a roll call, or you want to just be object? You're fine.
No, I'm not objecting.
Okay, everyone's good. Okay. Motions to concur. Senator Jackson, you want to read that on the floor? Actually, I don't know if the chair does that or not. But.
I usually they go to you.
Okay, that's fine. I take it. Lawsuit.
And do you want to do Senate Bill 105, which is your stimulus, peace order workplace violence?
Senator, yes. Senate Bill 105.
So this was the workplace protective orders, so peace orders. So what the House did is they took out JPR's two amendments. The two amendments that JPR had adopted, the first specified that the bill may not be interpreted to create or impose a duty on the employer to file a petition on behalf of an employee. And the JPR amendment also removed an immunity in the bill that the bill created for employers. The provision would have made employers immune from any civil liability that may result from the failure of the employee or the employer to file a petition on behalf of the employee under the provisions of the bill. So now the Senate bill with the House amendments striking JPR's amendments put the bill back in its original posture. So the immunity is back in the bill.
Immunity in the bill or out?
They put it back in.
We took it out, they put it back in.
I know from speaking with the sponsor and the original advocates for this bill that that's the posture in which, and I think out of courtesy to the original sponsor, I'm happy to accept what they've done.
All due respect, yeah, respect the sponsor and the intent, but let's just, can we focus on the merits? But go ahead.
You probably were going to address it. I just wanted, I apologize, like Senator West, I'm a little slow this morning. I thought we put the immunity in. We did not? They already had it in? Okay, we took it out. Okay. And now it's out. It's in. It's in now. Okay. So duty is in or out? Out. There's no the language that there's no duty. I can live without that because I don't think that was necessarily necessary.
That's why they added the immunity, because if you fail to do it,
Gotcha. Okay, sorry, just
then
wanted to
you'd
be
be
clear.
immune.
To file a petition, right? That's all. Yeah, I could, second.
Yeah, just quick. So now it says an employer shall be immune from any civil liability that may result from the failure to file. Was it always just that way? I thought there was an immunity for filing or failure to file. Was this what it always was, Gene? I'm sorry, who's had this one?
I'm trying to find the exact line where it is.
Was it always?
So I'm looking at the amendment. So it says, this is the Judiciary Committee amendment. So on page 5, after line 5, insert, an employer shall be immune from any civil liability that may result from the failure of the employer to file a petition on behalf of an employee under the provisions of this subtitle. So that is the immunity.
If my recollection serves, here's why we took the immunity out. Because a victim could go to an employer and say, here's what happened. And the employer can say, all right, got it. We're going to file a petition. And they agree to file a petition explicitly telling the victim that it would happen. And then when they fail to do so, the House bill immunizes them from their failure to act. So what our solution was to say, you don't have an obligation to file, but basically if you say you're going to file, or you file and do so in a way that is in error, you are not immunized for that error. In other words, once you make the pledge to do it, you have to do it. And that was the policy goal that we had. We don't want to affirmatively require that someone file it, but once they make the pledge to do so, they have to see that through, because as a domestic violence victim, you are relying on the promise that was made to you by your employer. And so immunizing them in those circumstances is not appropriate, because you're hurting, by doing so, you hurt the very domestic violence victim that the bill is intended to help. That's why we made that policy. So that's why I think we should, I appreciate what the advocates want, but I think we were right on the merits. And so that's why I would encourage that we not concur.
If I might ask, just in listening to the explanation, I believe we had also put in the language that there was no duty. So if there's no duty, you still wouldn't be able to come after the employer, even if they made that promise, right?
I don't think so. I think that's why we added the language. In other words, you don't have an affirmative duty to go out of your way to file, but once you've made a pledge to the victim to do so, you have essentially created your own affirmative duty, because the victim is relying on the promise that you made. And so if you hear that there was some fight in the parking lot, you don't have an affirmative duty to go and say, hey, what happened? Can I file on your behalf? That you don't create an affirmative duty. But if a domestic violence victim comes to you and says, here's what happened, will you file? And the general counsel or HR says, we got it, we will file. And then they fail to file, even though the victim is relying on what they believe to be a forthcoming protective order, then the liability still attaches, and we don't want to immunize that bad behavior. That was the fact scenario that was presented to us, and I think why we adopted the language, which made sense to me, then and now.
To be honest, I don't recall that conversation, but I understand what you're saying, and I feel like, can't we write that into this? Because that's a unique circumstance. I mean, I don't know that the House was thinking about that when they put that in, nor the drafter of the legislation. So that's a very particular.
Concur and then go to conference and work it out.
I defer to the sponsor of the bill, but it seems to be able to address that particular issue, I think it's doable.
All right, Senator Weston, Senator Castley.
I agree with Senator Hedelman that this sounds like a relatively rare occurrence where an employer would promise to file a petition and then fails to do it. a far more frequent occurrence would be an employer hearing something happened and saying, I'm not going to get in the middle of this. I'm not going to file any petition at all. And then someone sues the employer for failing to file a petition. And this, I think this immunity language, as written here, was written for that sort of a situation. If we'd intended to refer to your situation, we would have written that an employer to be immune from any liability that may result from the failure of the employer to file a petition after having agreed to file a petition. And that's not the way this reads.
So the proposed hypothetical that Senator Waldstreicher mentioned was the testimony. It reflects the testimony of MAJ, which had proposed these amendments. And so Senator Waldstreicher's testimony, or what he just stated, reflects the amendments that JPR had adopted about striking the immunity and with respect to the duty. So the hypothetical that he discussed would be covered under JPR's amendments, but the amendments that the House proposed would do away with that. The House amendment would give them blanket immunity regardless of whether or not they made an affirmative promise to request or to get a protective or peace order.
Two brief points. One, deference to local courtesy is logically based. Deference to bill sponsors, unless the bill is only going to apply to the bill sponsor and their families, makes no sense whatsoever. This is a statewide bill. Second point is that currently it's impossible for an employer to do this. So you won't find any cases where an employer has actually filed or done it negligently because they can't do it. The current practice, which I've personally seen a number of times, is for the employer to bring their employee over to the lawyer's office and say, hey, I'll pay your fees, would you file this for her? And what this bill would say is, rather than drag the victim over, they could go and say, look, here's the deal, can we get this filed? And so it's a whole new area of the law. So those are my only points. Thank you.
Senator Waldstreicher, I don't recall that conversation, but I'm sure it probably did happen. Is there anything in the bill imposing a duty once, is there any language in here that is linked with the civil liability where there is a duty, where there was an agreement? See, I don't see it in the bill. Perhaps you can point that out. But if we can't find it, maybe we should.
I think that's a better question for counsel. But to the extent that there is language that addresses the concerns, but because we can't amend it, we've got 100 hours.
Well, perhaps we should take care of it in concurrence then. In the.
We can work this out. It's not like we're running out of time. We're not on sine die.
Okay.
It's just.
Okay.
I'll defer to counsel on the question.
Counsel.
So the duty language that Senator Waldstreicher is referring to was the JPR amendment, which appears in line 3 or page 3, lines 8 through 9 of the third reader. Mm-hmm. Nothing in this subtitle may be interpreted to create or impose a duty on an employer to file a petition on behalf of an employee. This means that the employer does not have an affirmative duty to act. However, you can create a duty on yourself if you, in Senator Waldstreicher's hypothetical, the employer made a promise to act and then failed to do so. So
that's
before that promise, there was no duty. But once you initiate the process,
where is that
then there's
in
reliance.
The bill again? What page is that, Heather?
Sorry, that is page 3, lines 8 through 9 of the third reader, which was struck by the House amendment.
Oh, okay. Okay. Okay.
Go ahead, Senator West.
So the language in our bill which said that there's no duty to file was struck by the House?
It was struck because they struck the no duty to act because they added in an immunity. So if you're immune, it doesn't matter.
Okay, so we need that immunity. If they struck the language about the duty, we need this immunity in there. Otherwise, you could have big problems across the board. Right?
Senator West, you had a motion?
Yeah, I'm happy to concur, but if we do concur, then Senator Waldstreicher's situation, which I think would be rare, would not be covered by the bill. And so everybody should know that if we concur, we're ignoring that circumstance in which an employer promises to file and then reneges on the promise and doesn't do it.
I'm just
I'm
saying,
not-
so why,
I don't
if
think
you
it's a
don't
big
concur,
problem.
you can just, it gets right across the desk later this morning, we get a conference committee appointed, you figure this out today, it's done tomorrow.
I'm sorry, what was that?
You could have this hammered out by tomorrow.
All right, well then why don't we, I'm happy not to concur and to ask for a conference committee and hammer it out by tomorrow and get it done.
But you all,
So I withdraw my motion to concur.
all right, so we're not gonna concur, we're gonna appoint a conference committee, is everyone okay with that? All right, let's do the conference, who wants to be on the conference committee? Sidnor is gonna be on there, Kettleman, and West, or Carter? Let's do Heddleman, Sidnor, Carter. Sound good? All right. Heddleman, Sidnor. Which one is that?
The criminal and sexual crimes.
Yeah. Yes. To what?
250.
All right, Senate Bill 250. Jamie.
Senator, actually, I don't have that one in front of me.
Jazz Lewis's cross-file of my bill that we passed, or the prison election bill, one of the two. Let's see, Lewis will go in here. This bill.
So Senate Bill 250, as the committee may recall, the version that passed out of the Senate altered the definition of sexual contact as it pertained to certain provision of fourth-degree sex offense. What the House amendments do is they strike that alteration of the definition and return the bill to its original posture. And also, they alter the title.
Move the title back to what it was before?
Yes.
Okay, well, I'm not agreeing with that.
All right, we got a motion not to concur. Committee. Who wants to be on the conference committee? Senator Lee.
Jill does. Jill does, and I do. Harder than Huff.
Yeah, I know. Carter.
Okay.
Castley. Bob Castley.
You want it?
What?
You want it?
Fine, yeah.
All right, there you go. All right. So then, by the way, Senator Carter, Senator Carter, Senator Carter, the other conference committee that you're chair of, how's that going?
Not going great. If you could speak to the other chair.
Got it. Okay. As in, have they
Oh,
appointed?
no, no, he just says that you're busy, so.
Okay, got it, got it. Okay.
You're chairing that one. Always did.
She is.
Good.
Okay.
Oh, no, Leah's chair of that one. Leah's
Okay.
chair, sorry. It's gonna be all right. Senator Lee's the chair of that one. Okay.
Senate Bill 43.
Senate Bill 43.
Criminal law enforcement officers prohibition on sexual activity.
You ready for that?
Yeah. So Senate Bill 43 provided that a law enforcement officer may not engage in sexual contact, vaginal intercourse, or a sexual act with a person who is a victim, witness, or suspect in an open investigation that the law enforcement officer is conducting, supervising, or assisting with if the law enforcement officer knew or should have known that the person is a victim, witness, or suspect. Also, the prohibition applied to a person who was requesting assistance from or responding to the law enforcement officer in the course of the officer's official duty, and retained a provision in existing law that applied the prohibition to a person who was in the custody of the law enforcement officer. There was a exception to a person who is a victim, witness, or suspect if the law enforcement officer had a prior existing legal sexual relationship with the person, and that exception was stricken in the other House amendments.
No, I mean, I had a problem with that provision when we put it on, so I'm fine taking that out. I would move to concur with what the House did. Yeah, because I don't think that's particularly relevant to the issue at hand at the time.
Yeah, go ahead, Senator West.
This sounds like a police procedural here. So you've got a policeman who is living with a partner, and that's been the case for several years, and the policeman's partner is a witness to a crime, and this bill therefore would require the policeman to cease sexual relations with his partner or her partner until after what? Until after the crime has completely been handled and in the courts through any appeals, so they have to live apart for 2 or 3 years? That doesn't make any sense. Why does that make sense?
But the prohibition applies to a law enforcement officer who is conducting, supervising, or assisting with an open investigation, and that person is a victim or witness or suspect.
Right. Again, it sounds like a police procedural. You'll see on television, Sipowicz is living with his girlfriend, and they've been together for years, and the girlfriend witnesses a crime, and Sipowicz is one of the people who's involved in investigating the crime, and so they have to move out and live separately for 3 years until the trial and all the appeals have been concluded. It sounds like great for a TV drama, but not so great in real life.
So I'd have to say, when we're talking about somebody that witnesses a crime, I think there's some different perspectives here when we talk about where we come from. And if we're in a small rural area, when we say that because somebody witnesses a crime, all of a sudden that relationship is over and you can't have it, I think when we put in this amendment, I thought it was very well thought out. It applied and it worked, and there is, as Senator West says, we already have procedural issues like this that deal with fraternization, that deal with issues. It's already a crime if you are going to use some influence over that crime and your relationship. But the fact is, if you were dating somebody that witnessed a crime and you just got listed on that witness, all of a sudden you have to cease everything. I would move to not concur.
Yeah, I'm trying to understand the folks who want to move forward with this. Originally, the law related only to people in the custody, that you sex with mother in custody. So that was a pretty bright line test. I mean, it doesn't matter what your sexual relationship is. If once you've got him in your custody, that's got to stop. Okay. If you have a problem with that, get another officer to respond. But we struck all of that and really broadened this a lot. So it has nothing to do with custody. It's about a person. You're in a relationship with a person, and that person is now a victim, witness, suspect, but just try victim or witness. That the law enforcement officers conducting, supervising, or assisting with. So that's so broad, because if your spouse says, hey, I think somebody stole something out of the garage, and the other spouse is a cop, and so they're investigating that, they'd have to say, oh man, this really sucks, because now we have to stop all sex during the course of this investigation. I mean, that's how broad this is. Or, requesting any assistance. This would apply if you have a sexual relationship and your partner says, look, I need some help with this. Somebody broke in my car on the front side, out front of the apartment building here. You'd have to say, well, wait, okay, sorry, but we can't have sex now while I do this. It's going to be, the next 3 days while this is open. This is preposterous. So our exception just takes something that's ridiculous and makes it sensible. So I don't see how what we did to this in any way doesn't protect, in any way diminishes the protections that one would expect for victims or witnesses in these cases. It doesn't in any way degrade that, and it just makes it a more common sense bill.
Thanks, Mr. Chair. I understand the concern that's being raised. I just feel that we're looking at it kind of like with a reverse logic, because I feel that if people are in an intimate relationship or married, and one should become a victim or witness, that there would already be protocols in place dealing with conflict of interest, where they would then, in a professional capacity, have to recuse themselves from being the lead investigator or detective or whatever on the case, or even police person. So, I mean, I defer to the law enforcement professionals here to speak to that, but to me it doesn't make any sense. I mean, in any other profession, when one of our partners or family members becomes involved in something, the common sense response is that we just recuse ourselves from the case.
I'll just second the motion not to concur. That's all I wanted to do. Senator Bailey's motion.
Thank you, Mr. Chairman. I think what Senator Carter just said is exactly right. There is no reason that person needs to investigate. It's just excessive entanglement, and it seems like there should be protocols, and it just makes sense to avoid a conflict of interest in any way. So I don't have a problem with what the House did. I would move to concur with the House.
So what we just discussed here was talking about the lead investigator, right? This law does not stipulate anything to do with the lead investigator. It has to do with any police officer in that department that would be involved in any way with that investigation or on that scene. When we are talking about a very large police department that has a lot of people in an urban area, I don't disagree, but we have already, through departmental guidelines, conflicts of interest that exist right? You have to step away. You have to recuse yourself. What we're talking about is, wait a minute. You've got two people on a shift, one person in a rural area, one person had a relationship with one of the witnesses on this case, and guess what? You know what? You're going to send somebody in there by themselves. You can't even send somebody to the scene to help out with any part of an investigation, whether it be security, whether it be whatever. This is just a little bit ridiculous to go down this road, and it has nothing to do with the lead investigator. It has to do with any person in that police department on that investigation.
Yeah, okay. All right. Okay. I just want to make a broader statement on this bill and others that we're having a real challenge this year, I think, in this committee on recognizing that that the world is not major counties, that you know, we've got, 24 jurisdictions, and we've got like three or four that are really big, and then we have a whole bunch that are smaller. And you just have to account for the fact that when, in certain areas, when you call for the police, you can pretty much know who the heck is showing up, right? It's that officer in that area. And we did this yesterday on the LEOBR bill, where we put this piece in there that said that you have to have an ALJ or retired district court judge. You're not going to find them in these counties. We've basically just shut down trial boards in a lot of part of the state, because to get a retired ALJ who can, or a district court judge who can pick up, $300-400 an hour for arbitrations and mediations, is going to say, well, I'll give you a half a day for free. It ain't going to happen. It's just, so we're creating these things that look great when you have a county of over 1 million people, but when you have a county of like 50,000 or less, you've shut them down. You've put these impossible burdens. So you just have to balance this out, folks, and look and recognize that what makes sense in your county, where you have virtually unlimited resources, a huge body of people, just don't work in a lot of the state, and you're creating these just impossible hurdles. So a little bit of empathy would be appreciated.
Thank you. So I think when the bill left out of here, we took out in the custody of the law enforcement officer, correct? Jamie?
That's the existing law, Senator.
Isn't that bracketed?
So it is at line 3, but it was put back in at item 3 below. So if you go, it is bracketed, but
Okay, got you.
yeah, that was just the lead-in language.
Got you. I think Senator West mentioned earlier, and there's always a stipulation regarding incidents where the officer, when there's a conflict of interest, that's already stipulated. And I guess I go back to the purpose of the bill, because that's already in regulations. If there's a conflict of interest. So.
All right, there's been a motion for not concur, and it's been seconded, so we're going to do a roll call.
Vice Chair Waldstreicher.
Yes.
Senator Lee.
Can you come back to me, please?
Senator Castley.
Yes.
Senator Heddleman.
No.
Senator West.
Yes.
Senator Sidnor.
No.
Senator Jackson.
Yes.
Senator Bailey.
Yes.
Senator Carter.
No.
Senator Huff.
Yes.
Senator Lee.
No.
Chairman Smith.
Yes, and so, the rails, what do you got? Conference committee?
Yeah.
All right. So Senator Heddleman's on the conference committee. How about Senator, we got to have at least one law enforcement officer. So Jackson, do you want to be on there? Or Bailey? Bailey, you're on? All right, one more. Lee, would you want to be on?
You just put a majority of people that voted to
For,
take the House position on the conference.
yeah, sorry.
If we're going to go into conference committee about this, I should.
Sorry, Senator, I got to balance this out here.
Why don't you take the people that voted not to concur with the Senate position on the conference or something?
Yeah.
And it's majority Democrat. And
Yeah, Jackson then, go ahead. So Jackson, Bailey, Heddleman. to Senate Bill 234.
Senate Bill 234 modifies the Public Information Act to require an officer, employee, agent, or contractor of the state or a political subdivision to deny inspection of specified records and inspection using facial recognition by any federal agency seeking access for the purpose of immigration enforcement unless provided with a valid warrant. State and local agencies that receive these requests must submit an annual report to the General Assembly. And finally, the bill restricts access to databases operated by state and local law enforcement agencies. You should have a packet in your amendment, an amendment in your packet. That's number 598676/1. So on the provisions of the bill that deal with the Public Information Act, the amendment would adopt the same amendments that were made to the House bill, specifically by adding a prohibition on an individual who receives personal information from sharing that information with federal agencies for the purpose of immigration enforcement, and by limiting the reporting requirement in the bill to apply only to the Motor Vehicle Administration, the state police, and the Department of Public Safety and Correctional Services. The amendment would also make changes to the database provisions of the bill, specifically by excluding the sex offender registry from the definition of database to ensure that that remains a publicly accessible system. And whereas the bill as drafted required that entities who operate databases would have to limit access to people who are acting on behalf of a law enforcement agency, the amendments would change that so that those entities would instead be required to deny access to individuals who are seeking access for the purpose of immigration enforcement, and people who seek access to the database would be required to provide their name, contact information, and unless they provide a valid warrant, a statement under penalty of perjury that they are not accessing the database for the purpose of immigration enforcement.
All right, so these two, we had the discussion about MDOT and DPSCS concerns. These two amendments have assuaged their concerns. Proof of that is in your voting packet. So first, I want to let's adopt the amendments and then work off of the amended bill. Is everyone okay with that? All right, great. Open for discussion. Senator Castley.
Whose concerns have we not assuaged with these amendments?
The people that came.
No, I'm looking on the government side. I realize there's going to be private.
None that were expressed in the testimony that we received. So no additional opposition was expressed by any government
Right, so
entity.
the port, I guess the big one was the port. So they're withdrawing their objections. I see, so this is that exchange, is that one email you gave us. That says that the port, MVA, and MAA withdrawing their, but, so the, okay, procedurally, MVA would like, but we don't have anything from, this is Department of Transportation, but the public safety doesn't, we don't have anything from them, do we?
Yeah, so they did not put anything in writing, but if you go to their written testimony that they submitted on the bill, their concern was really about the database piece, that some of their people in parole and probation and their case managers often access those databases, and they are generally not included in the definitions of law enforcement agency. So their concern was that the way the bill was drafted, it would have locked them out of those databases. But because the amendments basically, whereas the bill is drafted, basically listed who could access the databases, the amended bill would instead say who cannot. So they would continue to have the current access that they have under the amended bill.
Is for a favorable with amendments. We did. Yeah. It's been seconded. We do a roll call. Yes. You want to be added to the bill? Senator Lee, Senator Wallstreicher, Senator Hedelman, Smith if I'm not on it, and Smith, and Senator Jackson. Senator Sidner. Senator Sidner. Good.
Vice Chair Waldstreicher.
Yes.
Senator Lee.
Yes.
Senator Cassidy.
No.
Senator Hedelman.
I'm sorry. I was having a side conversation. I apologize. On the dignity with, yes, up, yes.
Yes. Senator West.
Yes.
Senator Sidnor.
Yes.
Senator Jackson.
Yes.
Senator Bailey.
No.
Senator Carter.
Yes.
Senator Huff.
No.
Chairman Smith.
Yes, the bill passes. Favorable with amendments. What? 9-3. All right. Yes, and we'll do the cross. We'll move the cross file. The House bill. It's in the same posture. Does everyone be recorded in the same way? Excellent.
Wait, hold on. It's in, we need to,
Sorry, we need to add the amendments to the House bill. Is everyone okay adding those amendments? Great.
House Bill 23.
Everyone's House Bill 23 is now in the same posture as the Senate bill. Is everyone okay doing that? Same vote as before. Just to be clear. Got it. All right. Now, Senator West, I want to bring up the Senate bill that we have out of rules, which is the cross file to your bill. It's House Bill. Sorry, the House bill. House Bill. I'm sorry. 409, which is the cross file to the JRA. It's House. It's Jazz Lewis's bill. It's the same. We just want to pass it out the same as before.
Hold on.
Okay.
Just give me 1 second because I gotta let me record.
I think it's already on his desk right now. House Bill what? There's nothing really to talk over. Just it's the same. It's already on the governor's desk. We're just moving the House bill.
Okay, I don't think I have the House. What's the House Bill number?
409.
Okay, I think it's on the list.
It's not on the list.
Yes, I have to add. Okay, it's on the other list. All right, so for the Senate version, I have Cassidy, Bailey, and Huff voting against.
Yeah. Okay.
Recorded the same?
Yes.
Okay.
All right. Let's hold the report out because I don't want it to. Don't report that out just yet.
What bill number?
All right. So who's counsel for that?
Josh.
This one, like it was amendment of House?
Yes, yeah.
So this bill, we have the House bill and the Senate cross file as well. So the Senate Bill 23 requires the state to pay a private home detention monitoring agency for the fees or costs incurred by a pretrial defendant who qualifies as indigent. A defendant who meets these criteria is not required to pay these fees or costs and may not be required to pay for a home detention monitoring device or GPS device provided by the jurisdiction. These defendants would be exempted from the requirement to pay monitoring fees assessed by the entity directly to the agency. Under the bill as drafted, funding for the state to pay these costs may be provided by the Pretrial Services Program Grant Fund. You have an amendment in your packet, which is number 863121/1, which conforms the bill to the version that passed out of the House by striking the provision allowing for funding from the Pretrial Services Grant Program Fund, and instead establishes a work group on home detention monitoring to study the costs. It additionally specifies that in 2022, the bills should be funded by federal funds, and it terminates the act 1 year after the expiration or rescission of the governor's emergency order. I would note that under the amendment, the work group would be staffed by DPSCS, and they did recently reach out to me just to suggest that the Governor's Office of Crime Prevention, Youth, and Victim Services might be better suited for that task.
All right, you got,
Yeah, I just want to offer an amendment, which is to add my language from Senate Bill 643 that we passed unanimously on absconding to this legislation.
Is this that? I mean, this is a work group, so I would like to keep this a clean work group that focuses on what we can do to ensure that people who are in pretrial and being forced, have as a requirement the use of these monitoring devices, not have to pay for them. So I feel like that is outside the scope of what the purpose of this bill is.
If I could just respond, I talked to Jamie. It doesn't violate single subject, and this is the last vehicle I have to get this absconding language out, so I think it's important. The House isn't moving it, so I would just offer that as an amendment on there.
I'm sorry. Senator Huff, could you remind us what we're talking about in terms of absconding?
43, which we already passed unanimously. It says absconding includes leaving an inpatient residential treatment facility that an individual was placed under a court order for drug or alcohol treatment with the permission of the administrator as defined in 8-101 of the Health General article. Where does it stand?
Yeah.
Stuck in the House. It's not going anywhere.
Oh.
With all due respect to my colleague, that is not relevant to this bill, and I'm sorry that there's no other vehicle, but that is outside the subject of this bill, and I want to keep this. I mean, already we're making it into a work group, which I'm fine, but this is an issue that's really important that is outside the scope of what your bill does. So I would resist that attempt strongly.
ayes have it. All right, so it's amended on. Everyone, it's conformed. All right, you want to roll call that? All right.
Vice Chair Waldstreicher.
Yes.
Senator Lee.
Just come back to me.
Just let you know, I protect your product just like I'm protecting everyone else in this committee's product. So.
Senator Castley.
Yes.
Senator Heddleman.
No.
Senator West.
Abstain for the moment.
Senator Sidnor.
Since Senator Edelman was the crossfile. I'm going to support her motion. I'm going to support her no.
Senator Jackson,
Pass.
Senator Bailey,
Yes.
Senator Carter,
Pass.
Senator Huff,
Yes.
Senator Lee,
No.
Senator West,
I'll follow the lead of the chairman, yes.
Senator Jackson,
I'll do the same. Yes.
Senator Carter,
No.
Chairman Smith.
Yes, okay, now, we'll go on to vote the bill out. It's been, so you have a quick amendment. Senator Walsh has an amendment.
Just a quick amendment. The GPS monitoring folks who need to be at the table were not provided that opportunity in the bill, so we need to add the GPS monitoring representatives as full representatives on the work group, please. My understanding is that the chairman of the House Committee is okay with that happening.
So, as amended, is everyone up on that? Senator Sidnor, sorry, go ahead.
The question, the question that I had is this particular work group, they're supposed to be, we're trying to look at ways of moving away from money and the like in pretrial. So I'm wondering if the inclusion of this particular member might have their own objectives that might conflict with what the work group might be trying to do.
I think we already adopted the amendment, but, so we all voted for an electrician's bill on the floor, and it includes electricians who have an interest in being the electrician industry. And so as a regular matter, we include industry that has a stake in the bill on work groups, and it's only fair if we say we want everyone at the table. I think it's only fair that everyone be at the table.
So, yes, everyone's, all right, everyone's okay recording as amended, everyone's okay with the bill? All right, Senate bill is before us now. The motion is to conform the Senate bill to what we just did with the House bill. Everyone's okay? Great.
And then I'm leaning above the bill travel with.
Yeah, I'm doing that right now. Okay. All right, so now we've got, Josh, you're up with 126 next.
So House Bill 126 prohibits a pretrial services program that receives a grant from the Pretrial Services Program Grant Fund from charging a fee to any defendant for participation in the program. The bill also extends from June 30th, 2023 to June 30th, 2028, the termination date of the grant fund within the Governor's Office of Crime Prevention, Youth, and Victim Services.
Yeah. It's House Bill 126.
We haven't voted on this bill.
Is it no crosswalk? You were a crosswalk?
I'm the crosswalker. We haven't moved it. I was waiting. But it should be non-controversial.
Yeah, exactly. So we have not voted on this, or the Senate crosswalk. Go ahead.
Locals totally eat the cost.
No, it's the opposite. It makes the pretrial grant fund eat the cost.
Oh, and the locals don't eat the cost then?
Correct.
Okay, all right.
everyone okay with that? Do you understand what the bill does? Is everyone okay? Yep. All right.
Motion's favorable.
Motion is favorable. Passed unanimous. All right, so we're going to bring up, what's the Senate cross file?
Senate Bill 229.
Same bill, same posture, same vote. Is everyone okay with that? Senator Wallstreicher? Okay, great.
Wait, is it in the same posture?
Same posture it is. Yes. All right, the next one we'll take up is just for Heather. This is House Bill 222.
Actually, that should be the.
Oh, sorry.
The cross
I don't know why I have it as cross-filed.
So this is House Bill 222 and Senate Bill 224. JPR is secondary on both of these bills, and they were voted out by EHE. Senate Bill 224 requires the Department of Public Safety and Correctional Services to take specified actions to provide individuals released from a correctional facility with voter registration application, and to inform individuals who are no longer incarcerated that they have the right to vote. The bill also requires the Board of Elections to adopt regulations establishing a program to facilitate registration and voting by individuals incarcerated in a correctional facility who have the right to vote, and report annually on the program. The bill would take effect June 1, 2021. So House Bill 222 was amended in the House. Those amendments created additional requirements for correctional facilities and created the position of voting rights ombudsman for incarcerated individuals, and required the Board of Elections to take certain additional actions. EHE amended that bill to strike those amendments and to place the House bill in the same posture as the Senate bill.
Senator Westman is good. Anything to say?
I'll move the favorable report on both bills, and the bills will be identical to the one that I introduced here, and it just makes so much sense. I believe strongly that every person has a right to vote. Everybody who has a right to vote ought to be able to exercise that right. The simple fact is that people in jail in jumpsuits behind bars, many of them do have the right to vote, and they don't realize they have the right to vote. If they're felons, they don't. But if they're misdemeanor, convicted misdemeanors, they do. And more importantly, these days, because of the bail reform we passed several years ago, the judges are leaving more people in jail these days than used to be the case who haven't been convicted of anything, but they're awaiting trial. They have the right to vote. So all those people in jail who have the right to vote should be informed they have the right to vote, and the jail correctional people should facilitate them getting ballots if they want to vote. That's what this bill provides.
Yes. I could not agree with you more on the underlying sentiment. The bail and the bail reform stuff, yeah, we'll discuss more on. But so go ahead, clarify. Hold on one second. Go ahead, Council, and then we'll go to Senator Sidnor.
So just to clarify, Senator Carter, the House bill was amended in the House, and it went to EHE as the primary, and they adopted an amendment to strike those amendments.
They went further than just allowing, but actually created protocols for how this would happen.
Yeah, correct. They added some additional requirements. They actually created a new position of voting rights ombudsman for incarcerated individuals who could take complaints and provide information. And they also required the Board of Elections to provide a toll-free number for incarcerated individuals to request information and report violations.
And even that, I said, we're only secondary on this, so we're just up or down, and even if we down it, it doesn't change it. So we should just up it. Well, it just goes to floor still.
Then we go back.
And we only have the House bill. The Senate bill is not before us, or are they both before us?
They're both before us. So the House bill as amended by EHE would be identical to the Senate bill.
If you want to move this, you just want to vote up and go, because we're secondary, we're not a primary on this.
If we amend, it has to go back to EHE.
Okay.
Senator Gasly.
I'm just trying to understand the bill, because, yeah, what's the bill number real? I'm sorry, give me a freaking, thank you.
Thank you. No, Senator Carter, she had made my point, and I just wanted to mention we probably spoke to the same advocates, and the amendments that were stripped by the Senate were actually things that were agreed upon from the State Board of Elections. So again, we are where we are, so I just put it out there just so that we know.
What do you want to do? Roll the dice? You're going to just vote it up or down now, get it moving.
What's the effective date of the bill?
It's June 1, 2021.
Okay.
What do you want to do?
We run the risk of not getting the bills passed if we do it. I do think that we might have to come back and fix and add to it. I think we probably will. And I also want to put out there that it was my bill some years ago as well, so I've long been an advocate that people that have the right to vote are given the ability to do so, that are held pretrial. It's a really critical step where right now, we're foreclosing those rights, and it's unfair. So, for those reasons, I'm going to say we keep it like it is so we can get the bill passed.
Excellent. I couldn't agree more. Let's motion for a favorable. We'll do a roll call vote on this.
Hold on. The House bill has amendments, correct?
Yes.
Okay, so the motion would be favorable
With amendment. Okay.
Right, okay. I just.
Got it. All right. Roll call.
Vice Chair Waldstreicher.
Yes.
Senator Lee.
Yes.
Senator Castle.
No.
Senator Heddleman.
Yes.
Senator West.
Yes.
Senator Sidnor.
Yes.
Senator Jackson.
Yes.
Senator Bailey.
Yes.
Senator Carter.
Yes.
Senator Huff.
Yes.
Chairman Smith.
Yes. Yes. Same votes on the Senate cross vote. Do we need to adopt amendments on that one as well, or that's fine? It's in the same posture right now. Okay. All right. Same votes. Excellent. Senate vote. All right. That's it. We'll come back afterwards session, depending on how long it is.